I'm Drew Stevenson. This is a lecture for my professional responsibility class about ABA Model Rule 5.4, the professional independence of a lawyer. Now, for my students, let me put this in context for the course as a whole. The rules that are 5.1 to 5.7 are actually about firms, so ethical rules that pertain to law firms or practices, partnerships, and things like that. And as opposed to a lot of our other rules that are about how to deal with clients or other parties or opposing counsel or judges, this is about organizations of lawyers and some of the ethical issues that come up there. And here we're specifically going to be talking about sharing legal fees or having non-lawyers that you're partners with. So let's go to our slides. And for those of you who, just to give you a roadmap of where we're going, we have a few big takeaways from this rule. So here's the big things that you are supposed to get out of this rule. Number one, do not share fees with non-lawyers, with a few exceptions. This includes your support staff. So you can pay your clerical staff, your executive assistants and receptionists and secretaries and paralegals, but they should be paid either a salary or an hourly wage, not a percentage share of the fees that come in. If you are paying your support staff something like 1% or 5% of the fees that come in, that violates this rule. So a non-lawyer cannot receive a portion, a percentage of your fees. They're supposed to have a preset salary. Secondly, you cannot have non-lawyer partners, owners, or shareholders of firms. And in some countries, we have publicly traded stocks in law firms, or you can have a corporation that owns a law firm or a share in a law firm as a subsidiary or a diversified investment or something like that. In the United States, all of the owners of a law firm must be lawyers. And other entities like accounting firms that employ a lot of lawyers cannot offer legal representation to clients with the lawyers that they have on staff. So let's go into our rules. 5.4a is about sharing fees or fee splitting. A lawyer or law firm shall not share legal fees with a non-lawyer. That's the blanket rule. And then we're going to have some specific exceptions. So first exception, I call the death benefit exception. An agreement by a lawyer with the lawyer's firm, partner, or associate may provide for the payment of money over a reasonable period of time after the lawyer's death to the lawyer's estate or to one or more specified persons. So if I can explain this, just to put it in context for a moment for my students, think about that you're a partner in a firm. Well, if you left that firm, you would have to cash out, right? They would have to buy out your share or something like that to leave the partnership because you are a co-owner of the firm. So what happens when a partner dies? Well, their estate technically becomes the owner of their share until it's cashed out. And so the firm can pay the whatever was outstanding that was owed. And so it could be buying out the ownership share, or if there were contingent fees that were owed to that lawyer, or a paycheck or something like that, that was supposed to be divided with that lawyer, now it's going to go into the estate. And from a very technical legal standpoint, an estate is not a lawyer, right? Even though it's the lawyer's estate. So we made an exception. You can pay the estate, or if you want to skip the estate process and probate and just pay the whatever would have been the lawyer's share going to the estate to a designated beneficiary, that's okay. This can't be a permanent thing. We can't be sharing legal fees forever, but we can for some reasonable period after the lawyer's death. Okay, let's go back to our slides. A lawyer or law firm shall not share fees with a non-lawyer except two. Here's our second specific exception. A lawyer who purchases the practice of a deceased, disabled, or disappeared lawyer may, pursuant to the provisions of Rule 1.7, pay to the estate or other representative of that lawyer the agreed upon purchase price. So I don't cover or spend very much time on 1.17 or 1.17 in my course. It's a very straightforward rule about selling a law practice, and we're usually thinking about a solo practice. So to explain to my students, if you are retiring from the practice of law and you're a solo practitioner, you can sell your firm as kind of a turnkey operation to a new lawyer, someone who just graduated from law school and wants to have their own firm, or someone who's been working as a lawyer for a while and wants to have their own firm. And what they can do is they buy something that's all set up, right, as a law firm. They can even use your firm's name, that you have a client base. Of course, you're going to have to notify the clients we have new owners and a new lawyer, and give them the option of going elsewhere. But you, a lot of times you have a furnished office already, a law library, support staff who know what they're doing and know each other, and so forth. So it can be a very appealing business, and it's no different than selling lots of other businesses, barbershops and hair salons and nail salons and other small businesses, restaurants around the country that are all set up and can be taken over as a turnkey operation. Now, we also, if you do that, of course, you have to really leave the practice of law. You can't go across the street and start another firm if your last firm is still using your name, obviously. Now, what happens when the lawyer dies or becomes too disabled to practice? Well, their estate is going to own their firm again as a turnkey operation and can sell it pursuant to 1.17. Okay, let's go back and go to our next specific exception. 3, a lawyer or law firm may include non-lawyer employees in a compensation or retirement plan, even though the plan is based in whole or in part on a profit-sharing agreement. Now, generally, remember, you are not allowed to pay any of your support staff a percentage share of the fees that come in. You're only allowed to pay lawyers a cut of your fees. So the partners in your firm, the lawyers, can get a share of the fees. Everybody else who works there needs to have a set wage, right? Now, your lawyers also could have a set wage or salary if you want. But so let's say you have a secretary or paralegal, either they need to be salaried or hourly employees. They're not getting a cut based on when your firm like wins a big case and has a windfall, their salary doesn't change, right? Now, the only difference is you can set up a retirement plan where you contribute a share of the firm's fees into the plan itself so that everybody's retirement benefits grow or something like that. This is a couple steps removed, as you might imagine, from immediately just giving everybody, all the support staff, a cut or a percentage of the money that comes in. Okay, next specific example, the nonprofit exception. A lawyer may share court-awarded legal fees with a nonprofit organization that employed, retained, or recommended the employment of the lawyer in that matter. So what are we talking about here? Let's say that the ACLU or the NAACP or the Sierra Club, one of these like advocacy groups that does nonprofit work, hires you to do a case, or maybe you do it pro bono for them, and then you are entitled to attorney's fees. So for example, under some of our civil rights statutes, if you prevail, the prevailing party in a civil rights case may actually seek attorney's fees, right? So you get these attorney's fees, and some lawyers would like to either split that with a nonprofit or give it. Now, you can just like take it as fees for yourself and then on as a side issue, make a charitable donation to the nonprofit. But we actually allow lawyers, if you were doing the case on behalf of the Sierra Club or the ACLU or the NRA or an organization like that, to kind of skip the step of taking it yourself as income and making a donation, and you can just give them part or all of the legal fees. We made a very specific exception. They do ask about this on the MPRE, and it should be a softball question because it's such a specific rule. You'll only have maybe one question about it, and the answer is yes, you can share legal fees with a nonprofit. Please note that this does not apply to for-profits that hire you. Okay, on to the next part of 5.4. 5.4b says a lawyer shall not form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. So let's say you have a friend or even a spouse who's a CPA, a certified public accountant, and you want to go into practice together. You can't really do that if you are going to be co-owners or partners of an entity, if part of what you're doing is the practice of law. Now, what you can do is you can have a law firm that employs a CPA as a staff member to help with the accounting. And then you can offer, under another rule that we've talked about, law-related services that are not exactly legal, but let's say accounting services to your clients using your accountant who's on staff. You can't pay them a percentage of the fees from that client. You can't split the fees with them, but you can have an accountant on staff. Similarly, an accounting firm can have lawyers who on staff in their legal department who advise the accountants. What you can't have is an accounting firm that offers to represent people because we happen to have some lawyers here. And or you can't have a law firm, a partner who is an accountant if you are also offering legal representation, whether it's legal advice directly to clients from the lawyer or representation, let's say in litigation. C, a lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services. Now, I want you to look at this rule. This should remind you of an earlier rule we saw in the course with 1.8, a conflicts rule about the third-party payer. And we talked about insurance companies are the most common scenario or example, but sometimes parents with adult children, like college kids, who need to hire a lawyer for their kid. And so you have someone who's not the person being represented. The insurance company hires lawyers to represent their policyholders, let's say. And you have to get consent, and they are not supposed to interfere with the lawyer's independent professional judgment. And so to that extent, the third party payer is also, you can see, part of this rule. And so to that extent, this rule is a little bit redundant of the third-party payer provision in 1.8. But this goes a little further and talks about those who recommend or otherwise employ the lawyer. So I want you to think about this. Some lawyers, especially the smaller the firm, the more this is true, have an individual who refers a lot of business to them, right? Who gets them a lot of their referrals. And it could be a really influential person in the community, or a doctor who sends all his patients a popular doctor who sends all his patients to his lawyer, or something like that. And that person cannot get a cut of the legal fees from your case. And they also can't tell you what to do. And this, I hope you can imagine, if you have somebody that sends you the bulk of your business, you want to keep them happy. But we have a problem if they start saying, by the way, you should settle this case, or I can't believe you're taking that case to trial, or you should ask for more money in that case, or I don't think you should raise this as an affirmative defense. Anything they're trying to do to tell you how to do your job as a lawyer is over the line. And it's not just over the line for them. If you're letting them do that, you are in violation of 5.4C. Now, also those who employ you. So you could have an anchor client, we call it, at your firm, somebody who is, your firm is dependent on financially. They give you, let's say, 40%, 50% of your firm's business. And then all of your other clients are kind of small potatoes by comparison. And sometimes we talked about this with our conflicts of interest rules. That can create a material limitation if that person is influencing how you handle your cases and how you do your job for other clients. And to that extent, this rule is restating that concern, that you can't let someone who employs you or hires you or is one of your other clients basically tell you how to do your job for other clients. Okay, 5.4D is the really controversial part of this rule because it's about multidisciplinary practice of law. And remember, in B, we've already talked about the problem of having like a non-lawyer partner. You cannot have someone who's not a lawyer be one of the partners or co-owners of your firm. D takes it a step further and says a lawyer shall not practice in the form of a professional corporation or association authorized to practice law if a non-lawyer owns any interest therein, except that a fiduciary representative of the estate of the lawyer may hold the stock or interest of the lawyer for a reasonable time. So a lawyer can own shares in a firm, and when that lawyer dies, those shares go to the estate. So technically, again, an estate is not a lawyer, but it's the estate of a lawyer. So we included an express exception for that. But the issue here is you can't have someone, let's say, who's an equity investor in your firm. So when you start a firm, if you want to borrow money, you're going to take out a loan and pay interest. You can't have someone who takes a 5% ownership share in your firm. This is something that makes law firms very different from all other businesses in the United States. So you may invest in a friend's restaurant, put up some money for them to get their launch their business, and take a 1% or 5% or 10% ownership share. People can't do that with your firm if they are non-lawyers. Please keep that in mind, whether it's an individual, and the same is true with entities, right? So sometimes we have companies that like to diversify their assets and holdings, and so they own ownership shares of other companies, and they cannot own an ownership share of a firm. Now, this is a rule that's pretty unique to the United States. We don't have this prohibition in a lot of the other industrialized countries in Europe. This has created problems with firms in America that want to merge with firms in the UK or France or Germany, for example, or Singapore or other Australia and so on, that do allow this, and because you can't merge with a firm if there are people that aren't licensed in the States who are going to be owners. Now, please keep in mind the District of Columbia has an exception to this that may allow a foreign firm to kind of incorporate or set up its home office in the District of Columbia. Watch out for that exception. But and that may be your only workaround. Similarly, a non-lawyer, you can't be part of a corporation if a non-lawyer is a corporate director or officer. In other words, if you have a board of directors for your professional corporation, or you are a law firm that's Dewey Cheatham and Howe Inc., you're going to have board meetings and a board of directors, and you cannot have a board member or director or officer who is a non-lawyer. And so keep that in mind. This is a point of corporations law. In everybody who's on the board or is an officer of the corporation, like president, vice president, secretary, treasurer, has to be a lawyer. Okay, and then 3, a non-lawyer, you cannot have a corporation or professional organization where a non-lawyer has the right to direct or control the professional judgment of the lawyer. And so I want you to think about this for a moment. In other industries, we have people who are really good, talented project managers or personnel managers and so forth, and companies will bring them in to kind of clean house, right, and get everybody on track and boss people around because they're really good at it, and they make the company more productive. Be careful with that in your law firm. We can't have a person in the firm who's telling the lawyers how to do their job as a lawyer, like how to represent people, if that person is not a lawyer. Now, can you bring in a consultant that's going to tell you how to do better client interviews, right, and show more empathy? Or can you bring in a consultant that's going to help you hone your presentation to a jury, right, your opening arguments and stuff? Of course, right, you can do that, but that person shouldn't have the right to tell you, you need to dump that case. You need to settle that case. You don't settle that case, you're taking that one to trial, or you better not raise that affirmative defense or something like that. If anyone who's a non-lawyer has an actual right to tell you how to do your job, you are in violation of 5.4D3. Now, just be aware, Utah and Arizona are in the process of changing their rules in this area to allow, on an experimental basis, maybe some multidisciplinary practice. And some of the other Western states are also looking into this. So I expect a wave of change. The ABA wanted to change this rule, tried to change this rule. The Center for Professional Responsibility made a proposal back in 1999. It went to a vote on with the House of Delegates in 2000, and we were kind of surprised it didn't go through. And so I think that this issue is going to come back. There's a lot of people that would like to have their firms be able to merge with either other types of corporations and professional entities, or with non-US firms, instead of just being a separate entity that's affiliated here in the States. Also, the big accounting firms have been pushing to be able to offer legal services because they already employ a lot of other lawyers. And so you have these organizations like Pricewaterhouse that operate in the United States, and in other countries where they have offices, they can provide legal representation, and here they cannot. Also, keep in mind that in April 2020, the ABA proposed some very modest verbiage changes to other sections of Rule 5.4. These are not as controversial. They're not big changes, and I expect them to be adopted at the next annual convention. Now, for my students, I want to tell you that for the MPRE throughout the year 2020, 2021, the rule that as I've covered it, is probably going to stay intact. But stay tuned. If you follow the legal periodicals and so forth, 5.4 is one of the rules I expect to change in the next few years. Okay, let's do a review question, shall we? Just to make sure you are paying attention. Would it be permissible under the current rules for a lawyer and an accountant to form a partnership, like co-owners of a firm, that would offer both tax accounting and preparation services, as well as tax-related legal representation? Yes or no? This is supposed to be a really easy question, and hopefully you know the answer. And if you don't, you should go back and review the video. And that concludes our video about Model Rule 5.4.